Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, as you all know that we are carrying a series on trademarks and copyrights, and so far we have conducted a numerous session under this series, and we believe that you might have liked all the lectures as lectures are uploaded for you on YouTube. So keep accessing those lectures and keep giving your feedback to us. Dear friends, taking our series forward, today we would be talking on laws relating to trademarks infringement, and for this very discussion we have once again with us in our studios Mr. Ashwini Sewal. Mr. Ashwini Sewal is Assistant Professor in IP and Data Security Laws, Faculty of Law, University of Delhi. So dear friends, let's welcome our guest Mr. Ashwini Sewal, who I believe continuously and persistently explains the topics with the help of most appropriate examples, which helps you in understanding the various aspects and perspectives. So without wasting any time, once again I would like to welcome our guest Mr. Ashwini Sewal. Hello sir, welcome to the EduSec lecture.
Thank you. Welcome viewers. We have in our previous discussions understood what are the different prohibitions given under the Trademarks Act 1999, especially section 9 and 11 prohibitions, wherein we have learned the absolute grounds for the refusal of registration of a trademark and the relative grounds for the refusal of trademark registration. After that, friends, I just recall for your convenience that we completely understood the procedural aspects for obtaining the trademark registration in India, wherein our primary focus was on section 18 to 23. I mean, those chunk of 5-6 provisions gave us the thorough understanding about the subject. I mean about the obtainment of the trademark registration in India. The niceties and intricacies relating to that we understood in our previous discussions. Well friends, today we have to start the law relating to trademark infringement in India, and this is a very crucial aspect or the subject matter of the Trademarks Act 1999, because under this subject one understands what are the different manners in which a trademark gets infringed, as to how does the trademark gets infringed, what constitutes the trademark infringement, and what are the different interpretational nuances and intricacies relating to trademark infringement in India, especially the law relating to trademark infringement, that is section 29. I read section 29 along with the section 30 as well, because it also provides certain exceptions to the rule of infringement. But for seeing the rule of infringement or for seeing what constitutes infringement, we have to primarily focus on section 29 and its widely worded language. Well friends, if we jump straight away to the key aspects that I am going to cover in my today's discussion, I have certain things to promise to you, that we will learn in this session the different facets of infringement as per section 29, as per statutory provisions of the Trademarks Act 1999. Then we'll move ahead and we'll see how does it happen, what are the different ways in which the trademark infringement take place, who is the likely person gonna take advantage or say gonna infringe the trademark of the registered user, and what happens if the trademark is not a registered one, then what kind of a remedy is available to the person. After that we will go into the niceties of the trademark infringement, the sections relating or the law relating to the trademark infringement, especially as I mentioned that section 29 and 30 are of utmost importance for us. Then we'll move ahead with the concept of passing off. Well friends, I would like to elaborate it little at this juncture. Well, when we talk about the passing off action, it is an action that is available as a remedy in case of a non-registered trademark to the person, and it is a tortious or a action in a common law available to the person. I mean, the one who has not got the trademark register, he can go through the passing of action, and one who has got the trademark register, for him the remedy is the infringement action, that is a statutory remedy available under section 29-30 of the Trademarks Act 1999. After that, we need to understand the distinction between trademark infringement and the passing off. Well friends, this distinction is very crucial, because you see, what happens usually and what is seen practically, the trademark infringement action is being initiated against the infringer, as well as the passing off action is initiated against the infringer, if it is a case of a registered trademark. But when it is a case of a non-registered trademark, then the only action available to the person is the action of passing off. So we need to understand the distinction between these two remedies, which are separate remedies altogether, sometimes availed together in the case of the registered trademark and sometimes availed separately. For the registered trademark, it is the infringement action that is initiated. For the non-registered trademark, it is the passing of remedy, which is a common law remedy that is to be initiated. So we'll have the threadbare distinction or the analysis of the different or distinction wala points of this particular aspect. Then we'll have certain case studies on trademark infringement. I'll cover as far as this infringement case study is concerned, I'll cover the Indian scenario or the Indian case studies. One or two case studies I'll invoke from foreign jurisdictions, talking or giving us the idea about the infringement action taken by the wronged against the wrongdoer. Well, then we'll have some case studies on the passing off. So these are the key aspects on your screen that I'm going to cover today, friends. Just have a look on these key aspects once, because these key aspects are very important part and parcel of the Trademarks Act 1999. And one needs to understand all these key aspects in a very subtle and meticulous manner, because these key aspects are invoked very often by the wronged person, by the person owning a trademark or using a trademark in the form of a registered trademark or in the form of a non-registered trademark. As well as these key aspects are important, equally important, I say, for the trademark board, I mean the registering authority, because they'll have to examine the application and they'll have to decide the infringement part sometimes on the grounds of section 29. As well as these key aspects are important for the judges in the courtrooms deciding the cases. I mean the courts of jurisdiction in the trademark cases, they'll have also to see the key aspects and understand these key aspects, because these are of much importance for them. If they don't understand these key aspects in their threadbare manner, in their thorough manner, they won't be able to decide and dispose of the cases in a smooth function or smooth manner. So we have these key aspects for the understanding of the audience, which comprises students and business entities, etc. Then the registering authorities, I mean the officials granting the trademarks and disposing of the matters relating or disputes relating to the trademark. And then finally for the courts, I mean the appellate jurisdiction as well as the first instance jurisdiction courts will have to understand, will have to kind of grasp these key aspects. So to my understanding, this lecture would gonna be very fruitful for all of you, friends. Let us jump ahead and see what constitutes trademark infringement in India. If you have a look at this slide, then I have marked 2-3 things that I'm going to cover when it comes to the different facets of the infringement, especially what constitutes the infringement. So the noticeable and notable provisions we'll have to see, section 29 and 30. Then understanding trademark infringement and the case study. This is our agenda for today. These are the deliverables for today's lecture and this session. Let us see what section 29 reads and what section 29 of 1999 Act says. Well, friends, if you have a look of section 29, before jumping to the language of section 29, I have certain points to make the important points to my understanding to be made and to be uttered at this juncture. See, section 29 has got 9 subsections in it, and several subclauses are there under section 29. If you see the entire composition of section 29, it is very widely worded provision and it provides and promises enlarged protection. If you compare section 29 vis-a-vis to the provision which was a corresponding provision under the Trade Marks and Merchandise Marks Act of 1958, in that act, friends, the language of the provision covering infringement related issues was not that wide. It was not that widely worded. It was not throwing that kind of a enlarged protection the way this section 29 of the present operative act provides and promises. So keeping in mind that this section 29 has got so many subsections and so many subclauses and clauses under it, it promises enlarged protection. The wronged person against whom the infringement has been caused, or against the property of the person has been taken away unauthorizedly or without his permission, he or she has got so many measures, so many grounds to invoke section 29, and he can easily get invoked all those grounds for the purpose of initiating an infringement action against the infringer. Let us have a look of section 29 and do the threadbare analysis of all the provisions of section 29 one by one. As I said that there are several clauses, let us take up all these clauses one by one. So jumping straight to the first clause, the first subsection, let us see what is covered under first subsection. It says and it reads, a registered trademark is infringed by a person who, not being a registered proprietor or a person using by way of permitted use. Well friends, I would like to pause here for a moment and I would like to draw your attention on a very pertinent point, that this language, and as highlighted by me, it says that a registered trademark is infringed by a person. It talks about the prospective infringers. It covers and gives an idea as to who all can be the prospective infringers. So it says that the person who is not a registered proprietor and who is a person not using a trademark by way of permitted use, they are the prospective infringers or are likely to be the prospective infringers of the trademark. Who all are the prospective infringers according to this language are demarcated and highlighted by me in this slide by blue color. If you see and if you notice that the person who is not a registered proprietor and the person using the trademark not because of the permission, rather he is using it without any permission, he is not a permitted user. If that kind of a person, the one who has been shown or who has been hypothesized as a prospective infringer, if that person uses the trademark in the course of trade. Another important aspect of section 29(1), it reads that if that person who is the likely prospective infringer, if he uses the trademark in the course of the trade, and I have highlighted this aspect in your slide, if you see that if he uses the trademark being not a registered proprietor, not a permitted user in the course of the trade. Well friends, it is explicitly written that one, if found using the trademark in the course of trade, if one uses the trademark in otherwise manner, say for example for teaching purposes I use a trademark, for the purpose of instructions to somebody, for the purpose of sensitization, for other purposes apart from the mentioned purpose explicitly uttered there in the language of the law, that if one uses the trademark in the course of the trade, and if that one who is using the trademark is not a registered proprietor nor a proprietor who has been given a permission by the owner of the trademark, then in that case, if that use results into what? If he uses the trademark which is identical with or deceptively similar to the mark in relation to goods or services in respect of which the trademark is registered, and in such manner as to render the use of the mark likely to be taken as being used as a trademark, then it constitutes infringement. So what we understand by purview of section 29(1) is quite easy to explain in a very nutshell and in very precise manner, that the one who is the person using the trademark, one who has not got it registered, he has not got it registered, he is not a registered user, he has not obtained the permission, he is not a permitted user, and he is found using the trademark in the course of trade while advertising or marketing his goods or doing other things which falls under the category of trade. Otherwise, if he does use the trademark, he cannot be objected, he cannot be restricted. But if he is found to use the trademark in the course of the trade, and that trademark used by him, being a non-registered user, being a non-permitted user, is identical with or deceptively similar to the registered trademark of somebody, then in that case, it shall constitute the infringement. Well friends, one more thing that is coming at the very end of this subsection 1 of section 29, if you notice, it says either he is found using the trademark in the course of trade, one proposition, or he uses the trademark in such manner or say in such a fashion that it is likely to be taken as being used as a trademark. So there are two things, there are two factors which are to be taken into consideration, or two bottom line points to be taken into consideration while gauging whether the infringement has been caused, committed or not. The very first thing, that the person has to be what? He or she has to be, the wrongdoer has to be non-registered user. The wrongdoer has to be non-permitted user of the trademark. He is found using it in the course of trade either, or he is found using it in such a manner which is likely to give an impression as it is being used as a trademark, as the mark, which is contentious mark, is being used as a trademark. So friends, let us see and bifurcate all these points one by one of section 29 subsection 1, and it finds that there are three things that come to the fore when we read section 29(1). The very first thing, who is not allowed to use the registered trademark? It is the non-registered proprietor and a non-permitted user who cannot use the trademark. When he is not allowed to use it in the course of trade, the very first thing. He is not allowed to use it when he is using it in such a manner or in such a fashion that it is taken as being used as a trademark. He does not use the trademark in the course of trade. The contentious trademark has not been used by him in the course of trade, but it gives an impression, it projects itself as if it is used as a trademark on the goods. Then also, you see, he or she can be refused to use or restricted to use the trademark. Moreover, he or she can be held liable for the infringement under section 29, which is a statutory remedy available in the case of the infringement. Then there comes the last point, what is not allowed to be used. The use of identical trademark is not allowed to be used, and the deceptively similar trademark is not allowed to be used. If the person is found using the identical trademark on similar goods or a deceptively similar trademark on similar goods, that is not allowed. So what does we get? What idea we get from this language? We get that the person if found using the trademark in other manners, not in the course of trade, not being presenting itself as if it is used as a trademark by a non-registered user or a permitted user, it is fine and it is okay with it. I mean, he or she can use it, but he should not use such a trademark which is identical with the similar goods, which is deceptively similar with the similar goods. He can use it on the dissimilar goods. This is what section 29(1) reads and 29(1) covers. Well friends, we'll take up one case law later on this particular section, but first of all let us jump to section 29(2), the next subsection of section 29, which reads that a registered trademark is infringed by a person who, not being a registered proprietor or a person using by way of permitted use, uses in the course of trade a mark which, well friends, this section 29 subsection 2 is similarly worded as far as its first 2-3 sentences or first 2-3 lines are concerned. It also says and talks about who is not entitled to use. I mean, the one who is not a registered user or not a permitted user, he is not allowed to use the trademark. In what situation? In the course of a trade, a mark which, because of its identity with the earlier trademark and the similarity of the goods or services covered by such registered trademark, he is not allowed to use a mark which, because of its similarity to the registered trademark and the identity or similarity of the goods or services covered by such registered trademark. And the third thing that comes under section 29(2), if the mark is because of its identity with the registered trademark and the identity of the goods or services covered by such registered trademark is likely to cause confusion on the part of the public, or which is likely to have an association with the registered trademark, then that kind of a mark or that kind of a use made by the wrongdoer shall tantamount to infringement, or it may initiate an infringement action against. It may be a very well ground for initiating infringement action against the infringer. If you have a look at section 29 subsection 2, friends, on your screen, there are 2-3 things which are noticeable and which I would like to elaborate further. And in particular this section 29 subsection 2 clause C, which reads a mark which, because of its identity with the registered trademark and the identity of the goods or services covered by such registered trademark, if it is likely to cause confusion on the part of the public, or which is likely to have an association with the registered trademark, that kind of a use made or done by the wrongdoer shall tantamount to infringement. What are the noticeable aspects and what are the key aspects of section 29(2) subclause C? If you see, it reads that if the use of identical trademark on the identical goods is done and it is causing a confusion on the part of the public, if it is found to have an association or creating an impression of association with the registered trademark, then that would constitute the infringement. Prior to that, if you see the language of clauses A and B, even under clauses A and B, friends, the infringement gets constituted. It does not mean that it is only under 29C that the infringement gets constituted. The infringement gets constituted even under clause A and B of section 29 too, but it is getting constituted in different manners. In clause A and B, if you see, it reads that a use of a mark with its identity or because of its identity with the registered trademark and the similarity of the goods or services covered by such registered trademark, or its similarity to the registered trademark and the identity or similarity of the goods or services covered by such registered trademark, it causes a confusion. So the confusion part and the last part of this clause, or say this subsection under section C, is common to be applied even on the preceding two clauses, clauses A and B as well. I mean, whatever ingredients and whatever elements are given under A and B, if they are found leading to what? Leading to the state of confusion or leading to the state of association with the registered trademark, then infringement gets constituted under subsection 2 of section 29 under clauses A, B and C as well. Well friends, as far as distinction between these three subclauses are concerned of section 29B or section 29.2, we see that this 29.2C creates a presumption, and it is presumed in such situation that the person has committed the infringement. I mean the registering authority, the court dealing with the matter never goes into the detail as whenever it is a case of clause C of subsection 2 of section 29, because it is creating a presumption, and presumption here means that the infringement has been committed because it is a case of use of trademark which is identical and it is used on identical goods, leading to the confusion or association of the registered trademark. So let us see what are the key features of section 29 subsection 2. It creates a presumption in case of use of identical trademark on identical goods and services, and that is under subclause C that it has been created. Then further, likelihood remains very high. I mean, in this case, when subsection C creates a presumption, as the goods are identical and the identical trademark is being used by the infringer, so the likelihood remains very high. In such a situation, it is very logical on the part of the court to presume that the infringement has been committed without going into the further details or further considerations. Then further it says likelihood here includes likelihood of association as well. Well friends, it is explicitly written, if you see section 29 subsection 2, that the confusion if gets created because of the above mentioned uses by the infringer, by the wrongdoer, then it constitutes the infringement. Another thing that is written there, or another not allowed thing that is written there, it says that if it leads to association with the registered trademark or with the earlier registered trademark, then also you see there is a possibility of infringement to take place, there is a possibility of some kind of a wrong to take place against the proprietor, against the user of the trademark who is a registered user of the trademark. Then there comes subsection 3, friends. Well, in the case of subsection 3, only thing that is given or provided under subsection 3 of section 29, it says in any case falling under clause C of subsection 2, the court shall presume that it is likely to cause confusion on the part of the public. This presumption that I just mentioned and the presumption that I just spoke, it is a presumption created under subsection 3, and subsection 3, you see, reads it in a very explicit and apparent manner because it reiterates the point that is given under subsection 2. It re-emphasizes the point that is given under subsection 2 so that the court shall presume that in such a situation when an identical trademark is used on identical goods, it leads to a confusion, and this presumption will help out the court in saving the time. Especially it helps out the court in granting the relief to the wronged person expeditiously. Well, after that, friends, after the reading of subsection 3, subsection 2 and subsection 1, I would like to draw the entire discussion in a very simplistic manner for all of you, for your convenience. Well, if you recall 29.1, friends, what is covered under 29.1? 29.1 is such a beautifully worded provision and giving us an idea as to who all can be the prospective infringers of the trademark. The very first idea that 29.1 provides, who all can be the prospective infringers, in what manner the prospective infringers can infringe it, and what is not allowed by the law, by the statutory provision in the form of section 29. So the three things that are provided to us by section 29, the non-registered user, the non-permitted user cannot use the trademark. When can he is not supposed to use the trademark? In the situation when you see he is using it in the course of trade, I mean either in the course of trade he is found using it, or he is using it in such a manner which is likely to give an impression as if the trademark is used as a trademark, or as if the mark in question is used as a trademark. And the examples I gave you to make you understand, in one situation where the person is found using it as a trademark in the course of the trade, say while advertising his products, while marketing his products, by naming his business entity with that trademark, by labeling those goods with his trademarks, these are the situations where he is found using it in the course of the trade, by affixing the trademark on the goods, by labeling the trademark on the goods, by say stocking the goods with that trademark, or there can be several manners or methods in which a trade can be done. Other situations, or the opposite, the other component where the person is using the trademark not actually in the course of the trade, but he is found using it, and the impression that his usage is giving as if the trademark is used as a trademark. Well, friends, the situation that is the other situation, or the second component of section 29.1 can be understood with a very perfect example. Say for example, one prospective infringer is not planning to use the trademark by affixing that trademark on his goods. He just uses it through an advertisement. He just uses it, say in some sort of commercial. If he uses it in some other manner which is not actually in the course of trade, which is not a part of a trade or a parcel of a trade, he uses it in some other manners. So those other manners, when he is found using that trademark, can also land him into the trouble, and he may have to face the infringement action, and this becomes a very good ground of taking an action of infringement against the wrongdoer, against the infringer. The second subsection of section 29, friends, if you recall, that has been just elaborated by me, is provision which talks about three situations, and it gives you the bottom line and gives us the bottom line to apply those three situations. The very first situation, when the person is found using the identical trademark on similar goods, then the person is found using the similar trademark on identical goods, and the third situation where the presumption can be drawn is a situation where he is found using the identical trademark on the identical goods. So these three situations are separate, and these three situations separately written here with a purpose. The purpose is to make the language more wide, moreover to make the language more all-encompassing in nature, so that it encompasses, it covers every kind of aspect, every kind of a nitty-gritty of the trademark infringement issues. Anyone who is found using identical trademark on similar goods, if that use made by him, not being a registered proprietor, not being a authorized user or a permitted user, will tantamount to infringement if it causes confusion in the mind of the public or in the part of the public, if it is likely to have an association with the registered trademark. Another situation given under 29.2, if the person uses a similar trademark on the identical goods or services, such registered trademark, if causes confusion on the part of the public, which is likely to have an association, that also results into the infringement. The third situation where presumption can be drawn, and this presumption, or the idea about the presumption, has been statutorily declared under subsection 3 of section 29, which reads, in the case of subclause C of section 29.2, the court shall presume that the infringement has been taken place. Sorry, I am really very sorry, it does not say that the infringement has taken place. The court shall presume that it has caused the confusion. So the infringement, whether the infringement has taken place or not, that has to be decided by the court. What court is allowed to presume as per section 29(3) is the presumption relating to the confusion which exists because of the use of identical trademark on identical goods, or say because of the use of a replica of a trademark on the replica of goods. Then that situation can be presumed by the court that it is likely to cause the confusion. They will no more be supposed, I mean the registering authority as well as the court will no more be supposed to see whether the actual confusion has taken place or not. They will not be supposed to go into the details whether the confusion has taken place or not, because they have been provided with the rule of presumption, and with that presumption they'll move ahead. Then in the proceedings the opposite party will be asked to defend the matter as per his argument. Well friends, if we move ahead after section 29 1, 2 and 3 understanding, we have 5 more subsections provided under section 29, and let us take all those 5 subsections one by one. If you see section 29(4), which says that the registered trademark is infringed by a person who, not being a registered proprietor or a person using by way of permitted use, if he found using the trademark in the course of trade which is identical with or similar to the registered trademark, and which is used in relation to goods or services which are not similar to those for which the trademark is registered, and the registered trademark has a reputation in India. Well, this is the language of section 29(4). We are going to cover it in the next session, friends. Thank you very much. Welcome friends. In this session we are going to talk about the section 29 of Trademarks Act 1999, which is very important section as highlighted by me in my previous session. This section 29 covers certain acts which constitutes infringement, and these are called various facets of infringement. And as I told you in my previous sessions that section 29 is providing enlarged protection to the wronged person or to the person having the having the trademark which has been infringed by somebody. We have read so far three subsections of section 29. Now we have to see section 29's language in detail further. We'll start in this session with 29.4, that is subsection 4 of section 29. If you see the 29.4 language, friends, it reads that the registered trademark is infringed by a person who, not being a registered proprietor or a person using by way of permitted use, if he is found using the trademark in the course of trade. What kind of a trademark if he is found using? The trademark which is identical with or similar to the registered trademark, and a trademark which is used in relation to goods or services which are not similar to those for which the trademark is registered. And again it says, a mark which has got the reputation in India and the use of the mark without due cause takes unfair advantage of or is detrimental to the distinctive character or repute of the registered trademark. Well friends, if you see the entire language of section 29.4, it tells a mark which is having the identity or which is having the identical nature, identical visual representation, identical phonetic similarity, identical in other aspects. If it is found being used by the person who is not a registered proprietor, who is not using it by way of permitted use on similar goods or on dissimilar goods, if the earlier trademark is of the reputation in India, and if that trademark which is being used by the person, identical trademark which is being used by the person, if that trademark is causing unfair advantage to the earlier trademark or is causing a detriment to the distinctive character of the earlier trademark, then that would amount to infringement of that trademark, of the earlier trademark. Then another situation that is covered under subsection 4 of section 29, it reads, if the mark is used in relation to goods or services which are not similar to those for which the trademark is registered. I mean, on dissimilar services the trademark is used. Even then, you see, the trademark may get infringed, and section 29 covers it beautifully by laying down a very concrete rule that if the earlier trademark is found of a repute and the later trademarks used because of the identical use or because of the similar use done on dissimilar goods, if it causes a detriment or takes unfair advantage of the distinctive character or repute of the earlier trademark, then that shall amount to infringement. Well, we'll take up section 29.4 in further detail with a case law. Let us jump to section 29 subsection 5, which to my understanding gives us 3-4 important points, and I have jotted down those important points one by one. Section 29.5 reads, and it basically provides us the details relating to use of a trademark as trade name, one situation. It postulates another situation where use of a trademark as a part of the trade name is being done, or further it says that use of a trademark is on the name of business concern, etc. If it is done by the person who is not a proprietor or is not a permitted user, then that also would amount to infringement. Well friends, there are 2-3 things that I would like to elaborate here at this juncture. When we use the trademark on the goods or with the services, there are some conventional methods of use of the trademark. By affixing that trademark on the goods or by making those services available with the name of those goods or say with the name of that trademark. Another conventional method of using the trademark by labeling those goods with that trademark or by putting the name on the packaging of the goods, or say by using the trademark while providing the services in the case of the services. These are some conventional methods. Another method, or say some advanced methods of using the trademark, or say some further methods of using the trademark, say use of the trademark in the trade name, or say use of the trademark as a trade name or as a say business concern, name of the business concern itself has been made of the trademark. Suppose I have got a trademark registered under the Trademarks Act 1999, which is trademark A with me. If I further use it as my business entity's name, my business concern's name, it is my right, I can do that. If I use it as a trade name for my business enterprise, I can do so. So there is a distinction between trade name and the trademark. Trademark is one which you have got registered under the Trademarks Act 1999, and the trade name, which is actually the market name of the organization, of the company, or say which is actually the name which is registered under the different statutes of the law, not under the Trademarks Act 1999. If it is a company, then under the Companies Act that name is registered, etc. If that kind of a name is being used, that is called a trade name of that enterprise or of that organization. So what if tomorrow somebody else without my authorization and permission is found using my trademark as his or her trade name, is found using my registered trademark as the name of his business concern or as the part of trade name of his business concern or his business entity, then it shall amount to infringement as highlighted and given in detail by section 29 subsection 5, which in actual language reads that the registered trademark is infringed by a person if he uses such registered trademark as his trade name or part of his trade name or name of his business concern or part of the name of his business concern, dealing in goods or services in respect of which the trademark is registered. Dealing in goods or services in respect of which the trademark is registered. Suppose I am dealing with the goods on which some trademark is registered. Being a dealer of those goods or those services, if I start using that trademark as my trade name, as the name of my business concern, I cannot do so. I shall be held liable for the infringement. Though, you see, in this case, I have been made entitled or I have been allowed to use or to deal with those goods or services, but I have never been allowed by the proprietor of the trademark to use that trademark as my business concern or as the name of my business concern or as a trade name of my enterprise. So on that particular aspect, you see, the wronged person can always initiate an action against the wrongdoer, notwithstanding that he is a dealer of those goods or he is dealing into those goods or services in respect of which the trademark is already registered. Well friends, moving ahead with section 29, then we have subsection 6 of section 29, and subsection 6 of section 29 as on your screen, it reads, for the purposes of this section, a person uses a registered trademark if in particular. Well, before jumping ahead or going ahead with the analysis of section 29.6, I would like to tell you its reason and purport, and I would like to tell you the rationale behind incorporation of this kind of a subsection. Well, section 29.6 talks about the various possible uses of the trademark to be done by the people, by the owner of the trademark, by the prospective infringer in that case. So there are several usages or uses given and enumerated under 29.6. Let's take all those uses one by one. If you read, then it says a person uses a registered trademark if in particular he affixes it to goods or the packaging thereof, if he offers or exposes goods for sale. This is very important to understand that it reads that if anyone offers or exposes goods for sale, puts them on the market or stocks them for those purposes under the registered trademark or offers or supplies services under the registered trademark, then it also tantamounts to use of the trademark. So if somebody today, tomorrow, tomorrow says that I have never applied your trademark on the goods, I just stock certain goods with that trademark, that would also tantamount to use, and he can be held liable for the infringement, and action of infringement can be initiated against him, notwithstanding that he has not applied the trademark on the goods, he has not applied the registered trademark or affixed the registered trademark on the goods or on the packaging, but he has just done what? He has just offered or exposes goods for sale with that trademark, he has just stocked those goods with that trademark for the purpose of the sale, he has just offered to supply those services and those goods with that trademark, not actual services has been supplied or rendered, still he can be held liable for the infringement, and action of infringement can be taken against him. Further, section 29.6 says, if he imports or exports goods under the mark, even in that situation when he imports or exports the goods under the trademark, he can be held liable for the infringement, and action of infringement can be taken against him. Importing and exporting here is very important, because in the case of the trademarks, you see, we see that the exhaustion takes place, or the principle of exhaustion applies. But as the law says, or as it reads, it says if anyone uses the trademark while importing the goods or exporting the goods, he shall be held liable for the infringement. So there is no restriction on any kind of export or import. I mean, in the sense that there is no such leeway given to a person to export or import the goods with the trademark which is a registered trademark of somebody. If one has got it registered, only he or she is allowed to import and export the goods with that trademark. If somebody else is doing it, then it shall amount to the infringement, and he has to take a permission before using the trademark. He has to become the registered proprietor or a permitted user of the trademark. Then we have another use covered under section 29 subsection 6, use of the registered trademark on business papers or in advertising. Well friends, for the purposes of this section, a person can be called or can be deemed to using the trademark, can be deemed to be using the trademark if he uses it on the business papers, if he using the trademark of somebody else's trademark which is a registered trademark, even in advertising. So there are different facets given under section 29 subsection 6 which are of avail and which are important to be seen and applied in all the different situations of section 29 together. I mean, all the provisions of section 29 will be subject to this particular subsection 6, because without it, it cannot be said that the person was found using the trademark in the course of the trade. He can use the trademark in different manners, and those different manners have been enumerated under 29 subsection 6 in a very wise and beautiful manner. So what can be the possible use or say uses? It is use by affixing the trademark on the goods or on the packaging itself. Use in the import or export of the trademark is equivalent to use of the trademark. Use of a trademark for offering or exposing goods for sale, for stocking the goods for the purposes of the sale, for offering the supply of the services would tantamount to use. Use of a trademark as a business concern or in advertising will also be equivalent to the use of a trademark the way it happens in the marketplace by labeling it on the goods, by affixing onto the goods. So that is how one can use the trademark, and if anyone who is doing that use without any permission or authorization, then he or she shall be held liable for the infringement, and an infringement action can be taken against him. Well, after the reading of subsection 6 of section 29, we have to jump to subsection 7 of section 29, which reads as follows, and some of the key points of subsection 7 are here in front of you. Well, it says, these are the simple points of subsection 6 basically covered by me. 7 says, a registered trademark infringed by a person who applies such registered trademark to a material intended to be used for labeling or packaging goods as a business paper or for advertising or services, provided such person when he applied the mark knew or had reason to believe that the application of the mark was not duly authorized by the proprietor or a licensee. Well friends, if you read it, I would urge to all of you to read it in a very wise manner. This subsection 7, to my understanding, is a beautiful section, and it has got certain important elements covered here. It says a registered trademark is infringed or gets infringed by any prospective infringer who applies such registered trademark to a material intended to be used for labeling. That particular material has not been yet used in the course of trade. Still, the manufacturing of that particular intended material to be fixed or to be labeled or packaged on the goods itself will tantamount to the infringement. If you read it again in a very wise manner, I would urge you to read again and again this clause. It says, if anyone is found using the registered trademark, not actually using it in the course of the trade or with the goods or with the services, he is found using it on the material intended to be used as a label or packaging goods or as a business paper or for advertising goods or services, provided that a proviso has been attached which says if the person did not know it that this particular trademark is registered, then he may escape the liability. But if he had a reason to believe that this particular trademark is registered trademark and he is not duly authorized to use that trademark without the prior permission of the proprietor, then he has to be held liable, he will be liable for that particular infringement. Well friends, if you take an example, say in a paper industry, the manufacturer of certain goods manufactures certain labels or the packaging. They do not manufacture the goods themselves. So that manufacturing of the labels or of the papers in the manufacturing industry done by them, they produce the material intended to be applied on the goods, say a label to be applied on the goods, or a wrapper to be applied on the goods, say a packaging to be applied on the goods, or a business paper is just produced by a paper industry. Even that would be called an infringement if done without the prior permission of the authorized user. So the owner of the paper industry, if found entangled or engrossed into making or manufacturing of such labels, such papers, such business papers or such packages, which to his understanding, which he knew at the time of manufacturing that they are kind of papers which belong to this enterprise, they are the papers having or bearing a trademark which is a trademark owned by that and that proprietor. If he is found using it or manufacturing that material intended to be applied at the behest of somebody who is not actually the proprietor or manufacturer, the somebody who is not the proprietor, he shall be held liable undoubtedly, but the paper industry owner shall also be held liable as per subsection 7 of section 29, because he never inquired and he had the reasonable opportunity to inquire whether the proprietor is a true proprietor of the work or not, whether he really owns that trademark or not, and if he had reason to believe that this trademark does not belong to him and he thinks that he has unduly applied those trademarks on those labels and on those papers, wrappers, business papers, etc., he is not duly authorized to do so, he shall be held liable. That is why it is said that section 29 provides an enlarged protection. It even covers whom? It even covers a third party, I mean the person who is owner of the registered proprietor, owner of the paper industry, not the actual infringer or the prospective infringer of the goods or of the trademark. Further, if you go ahead, then we have section 29 subsection 8, and this 29 subsection 8 talks about the trademark infringement by way of advertising. It talks about a situation where we see the infringement taking place either by way of disparagement or by way of tarnishment or etc. I mean, in the case of the comparative advertisement, it happens very often that a disparagement or a tarnishment or a denigration of the products of others and their trademarks are used in the comparative advertisement to denigrate their goods. Even that would tantamount to infringement, and this is a non-conventional kind of a trademark infringement which has been covered under subsection 8 of 29, unlike the preceding clauses where conventional kind of a trademark infringement was covered. Well friends, if you see the language of subsection 8 of section 29, it reads, a registered trademark is infringed by any advertising of that trademark if such advertising takes unfair advantage of and is contrary to honest practices in industrial or commercial matters. Well, there are certain established practices or some established patterns of commercial matters, industrial matters. If anyone is advertising the goods within the limits or within the purview of those established practices of commercials, within the established practices of industry, it is fine. I mean, one can use it. But when in the comparative advertisement, which is a good practice altogether, one is trying to denigrate, not to puff up the goods, rather he is trying to denigrate and disparage the goods of others by using the trademark of the proprietor of the trademark without his prior permission and authorization. Then it says, then subsection 8 reads, then that person shall be held liable for the infringement if he takes unfair advantage of that particular trademark, which is not a established practice or honest practice of the trade. Then if it further it says that if it is causing a detriment to its distinctive character, or is against the reputation of the trademark, it shall tantamount to infringement. I have certain examples and some case laws on this particular aspect on subsection 8 of section 29, which I'll cover in my later sessions, but I can give you the idea about those cases where in the commercials some celebrities of Indian Bollywood industry are seen comparing the two goods, comparing the rival company's goods, and while comparing those goods, the script of the commercial turns or leads to what? The denigration of the goods of rival company, the disparagement of the goods of the rival company. That is not allowed. He or she cannot disparage or cannot tarnish the image. Only thing which is allowed as per the honest practice of the trade in the commercials or in the advertisement industry, it is the puffing up of the products, it is the boasting about of the products, or the comparison to be done, at least maximum the comparison to be done, not the disparagement or the denigration. And by way of that kind of an advertisement, if the person is found taking unfair advantage, causing detriment to the distinctive character, then it leads to the infringement of the trademark, and an action of infringement can be taken under section 29 subsection 8. Apart from this action, segmental action under the under the commercial industry, under the advertisement industry, can also be taken against the infringer of that trademark. Well friends, after that we have one more clause left, that is subsection 9 of section 29. I say that this subsection 29, as subsection 9 of section 29 reads, where the distinctive elements of a registered trademark consist of or include words, the trademark may be infringed by the spoken use of those words as well as by their visual representation, and reference in this section to the use of the mark shall be construed accordingly. Well friends, the one promise that I made you in the very beginning, and the promise that section 29 makes, that it provides a enlarged protection, it gets manifested, it gets reflected by subsection 9 and its language. Subsection 9 does not cover the conventional kinds of trademark infringement. Rather, it says even in the spoken words, if somebody uses the trademark, even in a visual representation somebody uses the trademark, it shall tantamount to infringement. Or any of the part or the feature or the word of the trademark, if is being used in the spoken words or in the visual representation without authorization, not being a registered proprietor, not being a permitted user, that shall amount to infringement. And further, under subsection 9, in the very last line, the subsection 9 reads, reference in this section to the use of marks shall be construed accordingly. So it means that anywhere you judge or adjudge or say gauge the infringement, you will have to see it in line with the subsection 9, and you will have to see it in consonance with subsection 9. It has to be construed accordingly. It means one has to see subsection 9 and its ingredients while construing the use of the trademark in rest of the provisions of section 29. Wherever you construe use of the trademark, subsection 9 has to be invoked and referred. And the bottom line of subsection 9 is, even in the spoken manner, if the word or the trademark or the part of the trademark is used, even in say visual representation, the word or the features of the trademark is used or uttered, it tantamounts to infringement of that trademark. Well, that's all for section 29. We have so many infringement cases as far as the case study on section 29 is concerned, and with those case laws we will be able to understand section 29 and its intricacies in more detail. I promise you to clear the intricacies of section 29 in my later discussions along with the case studies. Thank you very much.
With this note, thank you, sir. Thank you so very much for giving us a very, very productive session. Dear friends, we believe that you might have liked today's lecture. So, if you have any kind of feedback or suggestions, then you can mail us at info.cc@nic.in. So, we would be meeting again very soon and would be talking on one of the another important topics under the series, trademarks and copyrights. Till then, take care. Goodbye. Thank you, sir. Thank you so very much.